Start the recording again. Okay. Before we get started, just wanted to put some information out there, kind of as a heads up. It's not really any detailed information. I am working on trying to get some more details from Department of Agriculture concerning their plans on the licenses. And what I've done is I've contacted my program manager at DCEO to see what she can find out, because it's obviously affects all of the things we have planned for support for licensees. So she and I talked this week. She's trying to get information directly from Department of Ag herself. So as soon as she gets some information, and if it's information that's shareable, I will share it with you. Because I also told her, in full disclosure, anything you tell me, I'm going to tell everybody unless you tell me I can't. So, and she knows, she's like, yes, I know. So as soon as I hear anything, even if it's something that's not publicly available, I will let you know. So I'm working on that. In the meantime, we're going to continue to move forward with these. And then for those of you who haven't applied for a license yet, and you're still working on, the paperwork or whatever, we'll still be able to support you with that. So, oops, okay. With that being said, I am going to turn off my camera and mute my mute my microphone and turn it over to Desiree to go ahead and get started with today's session.
All right, thank you, Tricia. Good morning, everyone. So we are in week 5 out of session 5 out of our 6. So we have come a long way in our HR journey here. Before I begin, I just want to do a quick disclaimer and just to let you know that I am an experienced HR professional. I've been in HR a little bit over 20 years now and had a chance to experience a lot of great things in HR in my journey, and it's very interesting, which is what I share with you during my presentations. I am not a licensed attorney, so any information I provide is for informational purposes only and is not intended to provide legal advice or representation. So thank you this morning. So with that said, getting into it, we have taken our journey over the past 5 weeks in connection to our employment life cycle. So we started off by, learning about the different federal and state laws that apply to employment, took that through employee recruitment and selection. We did employee management, and then employee separation. This goes back, as we get into leaves of absences, into type of employee or workplace management that we'll be going through. So as we look at leaves of absences and the importance, today what we're going to go through are leaves of absences in the work environment. We'll kind of talk about what these mean to managing your workplace with your employees. We'll start off by reviewing the federal leaves, and then we will go through the state leaves. And then there's some kind of optional leaves, best practices, things that you may want to look at having. We'll talk about the importance of establishing a leave of absence process and what that should look like. We'll let you practice the new knowledge that you've gained and going through scenarios. Then as usual, we will have questions at the end. And please feel free to ask questions also throughout, whether it be in the Q&A area or also in the chat area as well. So those are often welcomed as well throughout our presentations. So getting into leaves of absences, these are the list of many that we will be going through today. And we look at these and, sometimes companies will think, well, what does that mean to me? Does this mean that the first thing we jump to is, do I have to pay for this? And, well, how do I know which one applies and how do I manage this? We'll talk through that today, but this is part of, sometimes those landmines as business owners that companies can step into, that we want to make sure that you're aware of up front. There's no way I expect anyone to walk away from this as experts, but at least familiarity. So if something comes up through your journey of being a business owner, having employees, you'll say, wait a minute, this situation looks a little bit familiar. Let me look into this further and see if this is something I need to worry about. Many of the leaves of absences are based on company size. And so some of these leaves may end up applying to you, some may not, and are primarily focused on job protection and return to work rights, and not based off whether it's paid. Very few of these are actually paid leaves. So we'll talk through those as well as we go through. So federal leaves of absences. The Family Medical Leave Act is one that I'm sure many of you are probably familiar with, or also known as FMLA. FMLA was signed into law by President Clinton in February of 1993. This legislation was big because this was shortly after he took oath. There were two other smaller bills he signed, but FMLA, this one was his third law that he signed into existence here, and is one of the most influential laws in the employment and labor environment. This law came about because people were losing their jobs. They were finding out that they would go out on a leave of absence due to medical and would lose their employment, disability, and many different things that would come up that life would present us. And so it became an issue. And the goal is to often work to keep people employed instead of trying to find ways not to employ them. So by doing this, this law gives many of us protections in the work environment if we qualify under these things. What the Family Medical Leave Act does is it entitles eligible, and I have these key phrases underlined because we'll go through what these mean in just a moment, but it entitles eligible employees of covered employers to take unpaid job protected leave for specified family and medical reasons. This falls under the Department of Labor and is enforced by the Wage and Hour Division. So covered employers, what does that mean? Private sector employers with 50 or more employees and 20 or more weeks in the current or preceding calendar year, including joint employers or successors in interest to a covered employer. So what does that mean? So this pretty much means most companies, however, you need to have 50 employees, and that means 20 or more in the work week. This is important because around the country, we have many companies that are seasonal. This also may cover companies that have a lot of temps throughout the year, maybe project-based. So this law is not for people that maybe have people that come on and off the payroll. So, but for the most of the time of the work year, calendar year, carries this amount of employees. And as you notice, it doesn't say full-time employees. This just says employees. So whether someone's full-time or part-time, if they're on your payroll, then they're considered an employee for that amount of time. Another thing that it covers are joint employers. So when you have situations where I have clients that have kind of family interests, for example, there's companies that have one primary owner, but may have different companies with different federal IDs. Just because company A may have 20 employees, company B has 10 employees, and let's say maybe in the IRS, for IRS tax purposes, maybe they're looked at differently. Because there's a primary employer or employers under those list of owners for those companies, it connects those companies together, and all of those employee counts would cause those companies, those identities, be covered employers. Other covered employers would be public agencies with federal employees, and also public or private elementary and secondary schools. And these are regardless of the number of employees that they employ. When we take a look at eligible employees, number one works for a covered employer. So if I'm an employee and I qualify under these other areas. If I work for a company that does not have the 50 people, then I'm not going to, then FMLA is not going to apply, and I'm not going to be someone that's eligible to take that leave. So that's why it's so important that we have that covered employer to make sure that we establish, does this law truly apply to the company? So as a covered employee, this employee has worked for the employer for at least 12 months. And some of the things that have been new, so once this law came out in 1993, as many laws do, they go through their cycles, and there's things that they don't think about, you know. And so one of the things that we'll talk about in a minute is the military portion of it. There's things that they don't think about in regards to these until they come up or other people ask for amendments. And so one of them is that they're finding that sometimes people leave a company and they come back. And if I've worked for a company, let's say 10 years, I decide to leave for a year and come back, you know, is it fair that I have to start all over again in all respects? And so what they took a look at was saying, you know what, if someone has put in their time, let's not make them start all over again. So that's why it says at least the 12 months, and they don't have to be consecutive. And so if I come back and I've worked with the company 6 months, and I've worked 1,250 hours in that time, because the next portion of this is that I have to have worked a certain amount of hours within the last 12 months, even though I haven't been 12 months recently, because I've gathered that over the last 7 years with that company, then I'm okay to still fall under this. So there's a couple different caveats within that. And then the last portion of this is works at a location where the employer has at least 50 employees within 75 miles. And I'll tell you, there's times when some people will say, well, how, if a company is that big, then how would that not be? You have companies that are virtual and may not have one location. So if we have employees that are working remotely, which happens quite often, especially these days, right? If the companies are spread out, the employees are spread out, they may not fall under this. I had a client years ago that had over 500 employees, and because they owned, they had private storage that they did, so they had 2 or 3 employees that would work on the different storage sites, kind of like a public storage but family owned. They were spread all throughout the US. So because their storage sites were never closer than 75 miles together, even though as company size they had over the 50, they did not meet the within a 75-mile radius. So that was something that came into play with that company and many others. So these are all of the things, all the criteria that an employee and employer would need to meet in order for FMLA to be relevant in their work environment. If not, this would not be a law that you will have to be concerned about. But I do have, you know, different clients and things that say, oh, I know I'm teetering at, you know, 48 or 45. I don't want to hit that 50 mark, because a lot of your major leaves of absences start to come into effect when a company hits 50. The next part of this is the leave entitlement. So if we do find and see that we have a covered employer and a covered employee, then we go to the next step. So what does that mean for them? So this means that employees who qualify can take up to 12 work weeks of leave in a 12-month period for one or more following reasons. So the birth of a son or daughter, or placement from adoption or foster care, to care for a spouse who has or a son, daughter, or parent who has a serious health condition. And this doesn't always mean blood relatives. So a lot of times people think, oh, it's got to be my actual parent. You know, in the U.S., we have a lot of people that take in different folks and raise them as their own. So they have a portion of this is called in loco parentis, and that's called in lieu of. And that means if I took you in and I've raised you as my own, I'm the one that you know as your parent. If I have a serious health condition and you're my primary caregiver, and I could be your aunt, I could be someone court appointed, whatever that might be, then it would apply to this. Same thing, vice versa, for someone taking care of a son or daughter. One of the things I do want to highlight on this when it talks about for spouse, we have to remember the differences, and we'll come across this as we go into the different state and federal leaves. The spouse, the definition for spouse federally is going to be different possibly than what your state may allow. So for example, in the states that allow for same-sex marriage, because it is still not legally federally, the spouse in this means between a man and a woman. So if someone is in a same-sex marriage and is legal in their state and they fall under a covered employer and they're a covered employee, because the federal does not recognize spouse as same sex, then they would not be eligible for this leave. So you have some states that have added similar leaves that fall into this that would protect that. Illinois at this time does not, but there's other things as an employer that you may want to look at putting in place that would mirror this, that would allow for that. And also we take a look at for serious health conditions that makes the employee unable to perform the essential functions of his or her job. So an employee under their own thing. So this could be if they are, this covers, let's say, a woman in pregnancy, if they had to be taken off of work due to being disabled due to pregnant, because pregnancy is a type of disability. If someone needs to take off for a surgery or something like that, anything that takes them where they cannot work due to some type of known disability or covered disability, and we'll talk about that when we get into Americans with Disabilities Act, then they're entitled for this leave. And then the last portion is for a qualifying exigency arise out of the fact that a spouse, son, daughter, or parent is a military member. And this is another portion that was added recently. I don't want to say recently because it wasn't even in this decade, but recently, as of about 10 years ago, that was an addition to this because, you know, we have to remember at this time, we had just ended Desert Storm not too long before. So when we take a look at the time frame of when some of these were updated, we had a lot of our military members coming back and servicemen and women coming back injured from Desert Storm. And, you know, as they're making those transitions back into civilian life, 12 weeks just didn't work, especially when they're trying to arrange government benefits and things like that. So the law was amended to allow for additional time for anyone that fell under that. So an eligible employee can take 26 work weeks of leave during a 12-month period to care for a covered service member with a serious injury or illness. And that's also, again, when the employee is a spouse, son, daughter, parent, or next of kin of the service member. And the single 12-month period for military caregiver is addition to and different from the 12-month that may be for other things. So you may potentially have, if you fall under this and your employees fall under this, an employee that's out for two reasons. Someone could be covered under this leave and still have their own portion of the leave of the other portions of it to be out for in the 12-month period as well. Doesn't happen often, but it is something I want to point out that is that can be a probability. The other portion of this is that the leaves, those 12 weeks, do not have to be consecutive. And there's many leaves that are that way. So this is something that an employee can take what's called intermittent leaves. And so if someone qualifies, so for example, a type of intermittent leave would be for let's say I have my own serious health condition. Let's say someone's treating for cancer and they have to go in and out for different chemo treatments and things like that. So it may not require at that time for them to do their complete 12 weeks at a time, but around their treatment schedule, they may need to take a month or a week here and there. So those are times when it's intermittent. And so when it's intermittent like that, a company would need to definitely make sure that they're tracking that time. And so there's a way to calculate the total amount of time and hours that this employee would have to be out on, and every time that they take some time, whether it be for a doctor's appointment or it could be for a week at a time or 2 weeks at a time in there. It could just be half a day's of work to cover to go do that and deal with it. And they would deduct those hours from it. So I will warn you, leave sometimes can be an administrative taxing on a company and not the most fun to do, but it's important to stay on top of them and just to making sure that the employee is always aware of where they stand in the leaves and that the company is aware of what's going on and those managers. How are we doing so far? Any questions out there?
No questions in the Q&A box yet. Oh, no, somebody wrote no.
Oh, okay. All right, sounds good, sounds good. Okay. Our next leave is our Uniform Services Reemployment Rights Act, Reinforcement and Reemployment Rights Act. So again, you'll see a lot of these have acronyms. So in HR, we just say, you know, we have these long things for the law, and then we just say, you know what, let's shorten it. So you, Sarah. So the Uniform Services Employment and Reemployment Acts of 1994 was, it provides for the employment and reemployment rights of all uniformed service members. So USORA protects the job rights of individuals who voluntarily or involuntarily leave employment positions to undertake military service or certain types of service in the National Disaster Medical System. And USERA also prohibits employers from discriminating against past and present members of the uniformed services and applicants to the uniformed services. So what does this mean? So this means, and here's another one. So when we say covered companies, here's one that does not have a amount of employees that are covered, employers that have to be covered and to be eligible. So before we had FMLA is 50, this applies to all employers regardless of size, including people employed by the federal government. And a lot of times they will have that caveat because there are times when there's laws and things that apply to private employers that will exclude the federal and public sector employees. So this is one that applies to all regardless of size. So whether you have 5 employees on your team or 500, this would fall under you. So what does that mean? This really says reemployment rights. And again, as we look at the time frame, these are all again around where we have our servicemen and women that were coming back. And the issue is that people would go serve our country and then come back and not have a job. So to help protect their job rights, they have reemployment rights. So if you have someone that's away serving the country, whether they volunteered to do so when they're away at boot camp or something like that, or they were given orders to report out of the country because we were at a time of war, then they were able to do that knowing that their job was going to be intact and that they'd be able to, once they were deployed back home, be able to come back to their job and pick up. So this means that that active duty, so this affects anyone who's active duty and active duty for training, initial active duty for training, so they're leaving for boot camp, and active duty training, and we'll talk about what that means a little bit later on. Full-time National Guard duty, if they're absent from work for examination to determine, so pretty much anything related to them being a service member is protected to where they have return rights. And just confirming what uniform services covered. So pretty much anything that's in part of our armed forces are considered uniform services, and therefore those following employees would be covered employees. So Army, Navy, Marine Corps, Air Force, Coast Guard, anyone serving in a reserve capacity, Commissioned Corps of Public Health Service, or any other additional persons designated by the President in time of war or emergency. The law requires employees to provide employers with advance notice. And I'll tell you, sometimes advance notice can come 60 days in advance, sometimes it could come 2 weeks in advance, and sometimes there's little to no notice at all. So as long as the notice is, so that's why it does not define what advance is, as long as you've gotten it, right? So notice may be either written or oral, and may be provided by the employee or the appropriate officer of the branch of military. So no notice is required in situations where it's military necessity that prevents someone from giving notice, or if it's just completely unreasonable for them to give notice. USERA reemployment rights apply if the cumulative length of service that causes a person's absences from a position does not exceed 5 years. So, you know, some of you guys may be saying, well, 5 years, what does that mean? 5 years is 5 years. So if you have an employee that's been with you, whether it's 2 days, 1 day, 10 years, they get deployed, let's say they're a reserve member and they get deployed and they have to go overseas or to training or wherever they're deployed to for a year, 2 years. while you are open and in business, you are leaving that employee in your system on your payroll. Now, it doesn't mean, again, that this time is paid. This is just protected. So for a company that's smaller, sometimes someone may say, hey, I only have 15 employees. And you're saying I may lose this full-time employee for a year or up to 5 years, and I can't do anything. There's other options you can do in the meantime by hiring a temp person or something like that in that. But once that person is deployed back home and is able to come back, they do get kind of first dibs back at their job or a job similar to their job. Okay. The next leave we will go through is Americans with Disabilities Act, also known as ADA. So a little bit about ADA. The Americans with Disability Act was signed into law July 26, 1990 by President George H.W. Bush. ADA is one of the most comprehensive pieces of civil rights legislation. So earlier in our presentations, we heard a lot about Civil Rights Act of 1964 and also 1991. Most of it dealt more with other protected classes, but another protected class in there are our employees and people that have covered disabilities. And this prohibits discrimination against someone with disabilities and not wanting to hire someone because they may, to a company, may seem, let's say, not quite perfect for the workplace in regards to certain physical or mental limitations. But Title I of the ADA Act of 1990 prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures. Another area of this, and some of the laws don't cover just employees, they also cover applicants, and Americans with Disability Act is one of those laws. So not only do I have to accommodate employees in these certain circumstances, but also applicants as well. So it covers in where to application procedures, hiring, firing, advancement, compensation, job training, and other terms and conditions and privileges of employment. So for example, an accommodation might mean, and I've had this before, where I might have an applicant who has a hearing disability and limitations. So a way for interviewing may say, if I do an interview, let's say if my process is to start with phone interviews, then I need to have some type of system or work within their system to be able to give a phone interview through it's a certain system where you have someone that you will ask the questions to. There's a way that through the phone that they type in the information, and then that person on the other end that has the hearing disability is able to see that question, they respond back, and it comes back to you and you conduct your interview that way. If your interview was on site, you may hire an interpreter for the day, someone to sign language and help with the doing of that to help with making sure that someone who's hard of hearing is able to properly interview for a position. Now, that may not mean that during employment that you would have to gather all these specific resources, but at least in the initial phase of working with that applicant and potential employee. So some facts about ADA. ADA covers employers with 15 or more employees. Now, sometimes local states may have, and local ordinance may have a lower number than that, but federally it's 15 or more. It also applies to employment agencies and labor organizations, and the ADA's non-discrimination standards, of course, also extends to federal sector employees. So this also covers an individual with a disability who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such impairment. Now, when this law initially came into place, it was so vague, it was kind of confusing because, as you can see, what does this mean? Especially the part of, okay, a record of impairment. Well, if I can't ask people what their records are, how do I know if they have a record of it? So how are they covered? How would I know as an employer? Or if they're regarded as having such a impairment, what does that mean? Another thing that they did was they expanded on well, whether there's so many different types of physical or mental impairments, what does this mean? And what does it mean to substantially limit? Does substantially limit mean if I can't do it for a week, if that's covered, if I can't walk, that's a major life activity. If I can't dress myself, brush my teeth, those are different types of major life activities. But how long do I need to be impaired for this to be covered? These were things initially when this act was rolled out that it did not cover. So, and it's since its inception, they have come out to clarify some of these more. It's still pretty vague, I won't warn you, but it has given employers more guidance over the decades of this being enacted into law. So covered individuals, who's a covered individual? This is not an exclusive list of conditions, but it's kind of a good idea for companies to kind of go with. And we'll kind of go through what some of those are. But in the official terms, an individual with a disability is defined as, in the Act, as someone who has a physical or mental impairment that substantially limits regarded in the major life activities. And like I said, major life activities are caring for yourself, being able to work, so some of these things. And they also kind of extend it whether it be for a long-term time or a short-term period of time. So, you know, if I'm treating for cancer, it hopefully is not a long-term situation, it's short-term, but during that time, my being able to do major life activities is going to be limited. So during that time, I may be covered, but once I'm cured, I'm in remission and back, then I'm okay. However, if I have a record, so now my employer knows that I've had a record of such impairment, I may continue to still be, you know, protected. Okay. When we're looking at physical or mental impairment, and this was a big part of it, a lot of people don't, you know, look at handicaps as being and disabilities as being other than physical, right? We even notice that when we go park at the store, what's the handicap sign? Someone in a wheelchair. Today, there are so many more types of disabilities other than just physical that we deal with day to day within our own personal lives, and also it goes into the work environment. Mental disability has been one of the biggest growing portions of this in the past few years. This is something a lot of, you know, federally and states haven't understood really how to deal with and how to work with. And you have, you know, you will have employees that will be treating for all different types of things. I mean, I've had team members treating from anything from bipolar issues. I had an employee that had paranoid schizophrenia in the past. We've had extreme anxiety things. You have some where, you know, where it can cause outbursts in the work environment. So then, you know, how do we work around, you know, work within that? So there's a lot of things that are part of it. And, you know, if someone displays some of those, how do we accommodate, how do we work with it in the work environment to where we can help them keep their job, but provide them some accommodations to where they can where it fits for the employee and the company. And we'll talk about accommodations in the upcoming slides. But when we talk about physical or mental, you know, any psychological disorder or condition, and I will, you know, I will also give you a heads up, another type of condition that can be covered. We have sometimes employees that have sleep apnea. So kind of throwing these out as things that we don't typically think of as maybe covered that will fall under this. Cosmetic disfigurement, different loss, things that can affect your respiratory and cardiovascular and all types of different types of things, immune systems. The regulations also cover any mental or psychological disorders. We've talked about that. Intellectual disability, organic brain syndromes, emotional or mental illness, and also learning disabilities as well. So here's again a list. Again, this is not by any means an all-inclusive or exhaustive list of disabilities, but just really kind of give an idea of some of the things. Also, some things that are covered under disabilities is someone that's treating from drug use or alcoholism, because that's seen as a type of disability. So as long as someone is treating for that, then they are a covered individual. So if you have a team member that you know needs to, let's say, leave early on Fridays to attend AA meetings or something like that, then you know, you have knowledge that they have this disability and that they were treating for it. So some of the main ones, blindness, diabetes, cancer, autism, mobility impairments, HIV, multiple sclerosis, different depressive disorders. For example, I've had team members in the past that needed accommodations because their depression would allow them not to get out of bed in the morning. So one of the type of accommodations that the doctor would request was them being able to have flexibility in their start time for work. So that was something that we had to try to work within. There are limitations in some of the accommodations, but that's one of the types of accommodations that could come in. Some things that are not covered. So the impairment does not include these lists here. And so these are things that, that the law doesn't deem, one of the interesting ones are the compulsive gambling. Some people think, well, compulsive gambling, that's a sign of some type of mental disorder or something else. And that could be the result of something else. So it could tie in. But within itself is just a gambling addiction or problem is not covered. And some of the other things that are listed here, physical characteristics are not anything that's covered, although there is another law, GINA, that kind of covers some of the things with physical or gender-based things, but different personality traits. So psychoactive substance use disorders, when someone is currently abusing alcohol or drugs, they would not be covered during that time. So these are the things that, and part of being impairment, is not covered under these areas. So I've mentioned a couple times, I've talked about reasonable accommodation. So once a company determines that they're a covered employer and they have a qualified employer applicant with a disability who needs reasonable accommodation. So this means, and this is one of the importance in our training a few weeks back when we talked about the important things of having job descriptions and what should be included in those. In a thorough job description, you're going to put not only the duties of that position, but you're going to talk about physical requirements and some of the other work environments and situation for that job to exist in. Because if you have someone that comes to you and says, hey, I can't walk or stand for long periods of time, but they were hired to be a cashier, and on that job description it says stands for extended periods of times or 3 or 4 hours at a time, and I come to you saying that due to my disability, I can no longer do that, then this is a situation where we work on a reasonable accommodation. So reasonable accommodation for a restriction like that might mean it could be temporary and it could be long-term. A reasonable accommodation could mean, okay, so you can't stand, so if I provide a stool for you at that cash register, or you see this a lot of times in banking or at that banking station or something like that, is that enough to accommodate your disability? That could be all it takes. And so that's something that accommodates. That might be for a short time. That could be for the extended time. It may look at job restructuring and may have to look at modifying work schedules, reassignment to a vacant position. It could be, adding different equipment or devices. An accommodation can be as simple as I know I've had team members in the past that have asked for, those back cushions when you sit in office chairs to provide for back support. It could be as simple as that. It could be as more complicated as maybe a specialized or adjusted workstation. As long as it doesn't cause an undue hardship to an employer, then the law looks at it as to, okay, let's have what's called this interactive discussion. Let's work with this employee. Let's work with the doctor and find out, is there something that can be done for this employee? One of the things I'm working through now with the clients of mine is where they have changed the employee parking to. So they were in a situation where the establishment was closed, and as they have reopened to the public, in the past that they would have employee parking with employee shuttles that would shuttle employees to the employee interests of this business. Well, in doing that, now with the law and having enclosed places as different departments and different sectors of the economy start to open back up, one of the things that's still restricted in a lot of states are enclosed spaces and how many people can still be within 6 feet and things like that. when you're on a shuttle, it's hard to say, about sitting, and you have the air that can be recycling. So, and doing that, some states have said no closed spaces. So to accommodate that, and since there were no more shuttle services, they put parking for the employees closer to the work entrance of the location. However, in doing this, where they park in the parking lot and physically now have to walk over to the employee entrance is now a little less than half a mile walkway. So under ADA guidelines and local experts and things that we've talked to, they said, well, this isn't compliance, this isn't asking for too much. But when you have employees that may already be potentially overweight or have other things, like one employee has a prosthetic leg and things like that, to walk a distance like that they didn't before, now they're saying, hey, I have these other limitations and I can no longer walk this. My doctor says I can only do 200 feet or whatever it may be. So they're working through what's considered a reasonable accommodation. I noticed a question in the queue. Tricia, do we have a question regarding some of this?
Yes. So the question is, what if you are unable to accommodate? What recourse can you take to prove it is an undue hardship to cover yourself in case the employment is, I think it's supposed to say terminated. It says employment is termed. Oh, maybe it's a term employee. Do you suggest terminating?
Great question. We are going to get into a little bit of that, but I will say no. I don't suggest terminating, and I'll talk through why and where that's going to lead to in just a moment. But when we talk through, as we're looking through and thinking of different ways to accommodate, we're going to take a look at how long the accommodation is needed for. So if there's something, so for example, and this is an extreme example, if you have an employee that you hire, let's say your location, the work environment is on the second floor, and it's on the second floor of a building that's, let's say due to local code ordinances, it's not required to have an elevator put in. And so team members come, they go up the stairs, they get to it, to the second floor entrance. And let's say you have a person that you're looking to hire, or you've already hired, and after that, they are no longer able to get to that, and they are wheelchair bound or something. And, it's like, okay, so how do we get you to the work site where your work location is on the second floor, right? We look at accommodations. Now, if we're a company, let's say where we own the building, and there's an empty cubicle on the first floor, that might be the option. It may not be preferred, because let's say their whole department is on the second floor, but they're on this open space is on the first floor. The law isn't saying, okay, now we need to move the whole department to the first floor. It's saying, or it doesn't say, well, your department's on the second floor, so we can't accommodate you. It's saying, let's look at what's reasonable. Is it unreasonable to have that person take that spot, or maybe switch offices or cubicle spaces with someone down there to accommodate them? When we're looking at undue hardship, how much money is it going to cost us, and compared to how much money we make as an organization? Is it say, if the doctor's note says, well, no, they should have elevator access. Well, elevator access is going to probably undoable, just the cost of putting that in for most companies. That's going to be an undue hardship because the financial burden it may put on the company. So it's taking a look at those items and having what's called that interactive discussion and seeing what's doable. It may not always be, let's say, the most convenient to the company, but if it doesn't do an undue, mostly financial hardship, and they do have kind of a formula to kind of have to really, for an employer to really prove that this is financially taxing, then they really look as trying to accommodate. But let's say this accommodation is short term, and let's say we don't own the building, we don't have any workspaces on the first floor, all we have is the second floor. And the accommodation may, hey, team member, this is short term while you're healing, maybe you can work from home. So maybe this is for a month or 2 months, and even outside of a work from home policy, let's say that's not something we would usually have, but this is just only for an accommodation purposes that we may allow that. Or if nothing else works, we may say, you know what, we do not have an accommodation at this time. An accommodation is time off of work. So while they're healing, you may say, we can't accommodate this. So during this time, you're placed on disability leave, and then they fall into, other different kind of potential state or local ordinances in regards to how disability may work. But time off is a type of accommodation. A lot of companies forget that. So it's all these kind of list of checklist items to go through before saying you truly can accommodate it. Now, if it's such a burden to the employer to try to provide, there's no other ways to do it, or this is an ongoing. So let's say this is an ongoing thing. Let's say this person is now going to need to, let's say, work from home, but this isn't a situation or position that really can work from home just based on how the job is set up, or maybe other guidelines that, modify it and things like that. Then this may be a situation where this person cannot return to work. And but just before doing that, all these different things that a company would want to walk through and try to work with before. And one of the biggest questions I usually get from a company when we're doing time off as an accommodation, they'll say, well, how long do they have to be out of work for before we can no longer accommodate? And I will tell you, it can be a while, because this isn't, unlike some of the other laws and leave laws, has a certain amount of time that someone qualifies. I've had employees get hired, work for a company for a month, come to a position to where we couldn't accommodate on site what their restrictions were, so they had to be off of work, and they'll be out of work longer than they physically worked for us. So guidelines could be, that we do this accommodation of time away from work. Again, it's not paid, it's just job protection and return rights. Could be almost up to a year. That many attorneys are saying that it's safe between 9 months to a year before we look at saying, offboarding someone because they're not able to work, or we have no other accommodation. So I know it's a long-winded answer, but there's a lot that goes into the ADA because it is so broad, and different ways that the law really wants you to try to work with an employee before just saying, oh, we can't do that, we have to let you go. So all these steps you want to go through to really show that you're trying to keep this person employed. Does that answer the question? Any other questions from that? It's a great question. We'll get a little bit further also into the undue hardship, but there's so many different types of ways to accommodate. It could be a little bit of job restructuring. Now, what the accommodation doesn't mean, it doesn't say that a new position has to be created to help someone do their job, or a new position created for them to go into that may accommodate their disabilities, and do anything, let's say, out of the normal with that, other than what you would usually have in the work site. So those are other things that it does not require. And the situation that I'm working through with my client, with the people getting on site to the building to get into work, they have underground parking is being looked at. And they're saying, well, as we continue to reopen, we want to use underground parking and save those for our special guests, our specialty guests, our VIP members, and things like that. And one of the things that the attorneys had to remind them is saying, well, it's going to be hard to prove an undue hardship when you have that there and you are choosing, kind of your VIPs in business over what you're choosing to do for employees. So it's not saying that this has to be comfortable or easy or preferred, but really, is this a doable, a viable option that's a low cost option? Did I see another question pop up?
Yes. It says, is there a list of the reasonable accommodations that the employer can choose from?
There are some guidelines. There are, kind of, a list, but I'll tell you, it's definitely not all inclusive, just like the types of disabilities not all inclusive, because it's really going to, and sometimes it can be different from person to person, in the workplace. So it's not even a one size fits all. I've had team members where we've had to adjust work schedules in short amount of times, allow for frequent breaks because, the person had, let's say, irritable bowel syndrome and needed frequent trips to the bathroom. So maybe we reassign their work location, be closer to the bathroom. I've had persons that the accommodation was allowing them to bring oxygen tanks on site because they had issues with breathing due to certain treatments and things for their disability. So there's so many types of accommodations that can be done. So, broadly, it could be, the list here of job restructuring, modifying work schedules, reassignments of vacant positions, acquiring or modifying equipment or devices, adjusting or modifying examinations, having training materials, having qualified readers or interpreters. So those are some of the kind of basics that can be done. But it can definitely be different from person to person. Good question. Yeah, anytime dealing with accommodations and disabilities, I wish there was a one size fits all, but I will tell you there's so many things I've come across and continue to come across as an HR professional that are, have been very, interesting. So we want to make sure. Times when the companies don't accommodate in turn too quickly before really having the discussion can cause them, liabilities and legal issues. There was a major case with the grocery store chain where they had an employee that had a type of irritable bowel syndrome. So which meant that, it was being treated, but there were times where if she sometimes happened to eat the wrong thing or something like that would trigger it. So she needed to be able to stop what she's doing and get to the bathroom. Well, this employee was a cashier at a major grocery chain. The manager that she usually worked with was aware of what her accommodations needed to be. And for the most part, 9.9999 times out of 10, they accommodated. And when she needed to do it, she left. So she needed more frequent breaks, which is a type of accommodation. And so she would do that and she would come back and no problem. Well, unfortunately, on this one shift, she had a manager that was not quite familiar with her accommodation. And she said, hey, I need someone to cover me. I need to go to the bathroom and what have you. And the manager said, no, it's not break time. You need to stay at your work site. When it's break time, you go to the bathroom. And she tried to explain, hey, you don't understand. I have this accommodation. And she went into it and the manager was not budging. So because of that, this caused this employee to soil herself in the workplace. And I know, when I heard it, I felt so bad for her because I could not imagine having something that allowed me not to use the bathroom. And as a grown adult, using the bathroom on myself and having the embarrassment of still having to work in that situation and, possibly having your customers or coworkers know that. Well, the one time that they failed to accommodate her cost them big. So, it's important and when setting up accommodations that, definitely don't want to spread it out to the office and all the managers, but that's a need to know basis, but that the managers who need to know and that may be covering those areas are aware. Because as I've kind of mentioned in our other presentations, when your managers who represent you are there doing the managing on site, they need to be familiar with not only the hiring and discipline laws, but these as well, because 9 times out of 10, the employee is going to go to them first with what their issues are concerned for. And the manager needs to know enough about these things to say, hey, this sounds like we need to do a reasonable accommodation and be able to start that process accordingly. Do I see a question, Tricia?
Yes. Person says, I think I missed what you said. Do you still have to accommodate employees even after they leave?
Oh, I'm sorry. No, not after they leave. This is going to be your applicant. So incoming and during, not exiting. No, once they've turned in this respect, then the accommodations end at that point.
Okay, then there's a follow-up to the situation that you talked about before. What happened in that situation? Was the company fine?
And which situation? The one with, I'm assuming the one with the cash.
Employed herself, yeah.
Yeah, so no, the company wasn't fine. She sued. And so I don't want to say they weren't fine per se, but they had to pay money because if she would have just gone, let's say, to the EEOC to report it, then they would have had a fine attached to it. But another remedy for employees is that they can have a lawsuit outside of the government agency. They can choose to have the agency represent them or have legal counsel represent them. In that situation, she still filed her claim with the EEOC, but she had both. But to get more money, she had legal representation.
Okay.
Yeah, and there's a lot of times when a company gets sued, they look at a couple things. They look at if something happens one time, 70% of the time we'll say it's not an issue. But if that 30% like this is so severe in what happened, that alone can be enough to raise an issue with having a decent lawsuit with it. Great questions. Now I'm gonna throw a bit of a twist in here too. So as we see some of the things that we go through in ADA, it's under leaves, and within itself, it's not an official leave, but as I mentioned, a leave of absence may be a type of accommodation. Now, we talked not too long ago about the Family Medical Leave Act. If I'm an employee that works for a company of 50 or more employee, we may coordinate what we call coordinate leaves, okay? So we may have a situation to where let's say someone was in a car accident, and it was a pretty severe car accident. And from that, this person needs to do, let's say, physical therapy. They have surgeries relation to it. They'll most likely recover, but it may be a while, right? So they're going to have to be out of work. One of the things that a company could also kind of run at the same time and track is also those 12 weeks of the Family Medical Leave Act. So they'll let the employee know, yes, time off is an accommodation. You're covered under FMLA. We hope you feel better. Keep us posted. The employee does the 12 weeks of the getting better. Let's say they have their first round of surgery, 12 weeks ends. Now what? Does our accommodation end as well? Well, even though their leave time under another leave that you can maybe run concurrently during the process has ended, it doesn't mean, oh, we're done. They had FMLA that covered them. FMLA is gone, so they can't come back to work. Too bad, so sad kind of thing. No, they may have additional time off again as an accommodation, and still continue to be off even after their FMLA expires. But that's just to point out that you may have a couple of things that may work out in there that may overlap. And just because, let's say, one of the major parts that expires doesn't mean the other as well. So someone could still be off on just the ADA accommodation portion of a leave of absence. So what happens when we don't think that we can accommodate this, right? So we're looking at it and we say, oh my goodness, I don't know if we can accommodate this. And the situation I'm actively working through an accommodation now, and getting these employees from their parking garage over to the team member site to enter into the building to go to work, we're looking at other ways. How do we accommodate this? If we don't have a shuttle service, we can't do that. So, okay, do we get a golf cart to take them? Okay, well, a golf cart can maybe take one person at a time, because then we're keeping in mind social distancing. We think, okay, we need to maybe retrofit the golf cart and have the glass shield or plastic shield placed between the driver. That would be most likely an employee, to protect them from, the employee, if the employee getting on may have something. And then we can't have too many people on at a time. So if we have a handful of employees that need this accommodation, is the one golf cart enough? So are we looking at having to buy multiple golf carts? The company had also cut back. So then it's like, okay, so we may need to hire more people to run these golf carts. It's a 24-hour organization. So now we're saying we need to maybe run these to accommodate these 24/7. That's going to be multiple shifts, multiple employees. This is starting to add up, right? So between the cost of these carts, retrofitting them, they were estimating, I don't know, part of me thinks a little bit accelerated, but they're estimating that this is going to run into the hundreds of thousands to accommodate that. So then it's like, okay, the business, even in its 30% capacity of reopening, still does very well in the type of industry that they're in, even in that capacity. But even in that respect, is it an undue hardship to have them spend $200,000 to $300,000 to accommodate these types of leaves? Does this offer undue hardship? So when we talk about when a company cannot do it, that's some of the things that the law looks at in regards to can accommodate. Is it going to be and impose an undue hardship on the operation or on the finances to accommodate? And if it's kind of like, well, this is unreasonable, we cannot accommodate that, we can't have that, then that's something to take a look at. And then that would be an accommodation. And if a company cannot accommodate, then accommodation, like I said, could be the time off, or it could unfortunately mean that the employee can no longer work there. Another example I have of a client years ago that was a roofer, and they had an employee that started developing epilepsy. And it was not controllable. So he couldn't have, as you can imagine, could not have someone on the roof that could have these seizures and things and potentially really hurt themselves. And this is, it was an ongoing situation. So if the only types of positions that this company had were roofing, unfortunately, then they would be at a situation where the employee would not be able to be employed any longer, because this is something that time off is not going to fix. Luckily, the company had other positions on the ground that the employee was qualified for. So that's the other thing. This does not require us to create a new position. So it didn't tell the company, hey, company, they don't have this job. You need to now create a new position for them. Or if they're not qualified for something, kind of dumb down a position for them to do it. Part of that accommodation and kind of interactive process of working with an employee on other accommodations may be looking at other positions in the company to see what they're qualified to work for. And we don't have to flex in that. Another thing, let's say as a roofer, they're making $30 an hour because it's a highly skilled job. And now they have to now become, let's say, an on-site helper. Well, if it doesn't say that you have to continue to even pay them their higher wage. It says, well, hey, our accommodation is to move you to this position. And this is the position now, let's say is minimum wage, or is just above minimum wage at $15 an hour. That's their new position. So we're only, having to accommodate in regards to finding work for them. It doesn't say it has to be the exact same work, exact same pay, or any of those things with that. Okay, so it doesn't allow us to do anything that's outside, and that's above and beyond and all that. Sometimes companies may, and that's noble for them, but it doesn't require that. Okay, so I know we had the question of the undue hardship earlier. Are there any follow-up questions in regards to the undue hardship portion?
There's none typed in the Q&A yet, but here we have one. Okay. How do you prove a reasonable accommodation is a financial burden, undue hardship? Compare cost of the accommodation relative to how much money the company makes?
Absolutely. If a company is saying that due to financial hardship, that they're unable to, due to their financial limitations, that they're unable to do this, then they need to be prepared, if challenged, to prove it. A lot of times when you have a company that's smaller, it's a given, it helps. But again, if the industry is high revenue generating or something like that, an inconvenience does not mean, a hardship. So they have to really be prepared to show that, to have this person do this or try to work from home or something like that is so outside of what we do that it's not going to work, or it's going to be so financially such a hardship for us that it's not going to do it. And that means that they're going to be opening up their books to that government agency to show, hey, this is what we bring in, this is this, and really break it down to show that, yeah, this is going to cost, 30%, 50%, whatever the number is, to accommodate it, to prove that it's not going to work. So I would highly suggest, though, trying every which way to try to accommodate, because having to go back and get to the point to do that, as you can imagine, is going to cost additional time and money to defend, in those. But, there's times when companies just are not able to do it. And hopefully, if an employee does decide to file, it can be resolved quickly in the mediation process of that. But, they would have to prove and open up their books to prove, what they make in and their profit, and, showing time that they're, making that. Because if it's, let's say, a short-term reduction in profits, that may not, rule them out either. So, yeah, so the answer is yes to that you have to show all of that as proof. Great question. So undue hardship is defined as an action requiring significant difficulty or expense when considering in light of factors such as employer size, financial resources, and the nature and structure of its operation. Okay, so those are the federal leaves. And like I said, if there's any questions that come up as we go along, please feel free, and we can, go back and discuss some of the other ones. but now we have some leaves that are specific to Illinois. So, as I kind of mentioned in some of our first couple of seminars, is that you will have the federal laws that kind of set the foundation. And from there, states may either add to those federal laws or come up with some of their own that maybe the federal law, didn't, miss, or that they missed or didn't want to address because they wanted to leave it to the state level to do that. One of the laws that have come up is the Illinois Victims Economic Security and Safety Act. So in short, many states are adding different domestic violence leaves, acts and related to that, and that's what this is. So this allows employees who are victims of domestic violence or sexual assault, or who have a family or household victims who are victims of such violence, may take up to 12 weeks of unpaid leave per any 12-month period to seek help, legal assistance, counseling, safety planning, or other assistance. So again, this is something that does not have a minimum amount of employees that come with it. This is something that's situational. It doesn't require payment. Now, there may be payment provided through the states or through, let's say, a sick leave or something like that that the company may have. But again, it's just job protection. This allows them to go do what they need to do to protect themselves, protect their family members. This could mean going to court. This could be moving out and moving into a shelter or something like that, seeking legal advice or assistance. In some states, witnesses of this are covered too, and they've added violent crimes and stuff as well other than this. So I would suggest keeping an eye on this one because these are morphing into not only domestic violence, but also other types of violence and things as well as protection. The Act also prohibits employers from discriminating against employees who are victims of domestic or sexual violence or who have family or household victims. So this means that if I'm a team member and I call out last minute and I say, hey, this happened to me, I need to go to the courthouse and get immediate relief of a restraining order. You can't say, hey, well, our attendance policy, and you're due to be at work in an hour, and this is not 2 hours before, so we're going to write you up, or you're going to be terminated if you don't get in here or something like that. That would be in violation of this. Employers are prohibited from interfering with, restraining, or denying an employee's attempt to exercise their rights under the Act. So if an employer is requiring an employee to come in and work in lieu of getting those protections and things that they need and seeking, refuge and things like that under this law, then that opens them up for violation and lawsuits. Employers are specifically prohibited from discharging, constructively discharging. So that constructive discharge would say, you know what, if you don't get in here today, then, that we're going to assume that you quit, or something like that. So we're not firing you, but if you don't come in, then you're resigning, and we'll take that as your resignation. So that's kind of, in a sense, forcing them out. Harassing or otherwise discriminating against any employee with respect to compensation, terms, conditions, privileges of employment, or using this against them pretty much in any form or manner in the work environment. And I've dealt with a couple of these situations, and they can be very scary for the employee. So definitely work through doing what you can to protect them. A lot of times if an employee divulges that they're going to seek some type of restraining order or something, we let them know that once they have that, provide us a copy at the workplace. As you know, as we see the different shootings at work and stuff like that and workplace violence, a lot of them are domestic related. And these are relationships that spill over into a workplace that can not only be problematic for the employee, but also other employees. There was a shooting, I live in California, and we had a shooting a couple of years ago where a teacher was experiencing, she was going through a bad divorce, I believe, or a hard time with her husband. And she didn't let anyone at the school know. So, similar as when you go visit your spouse at work, a lot of times no one bothers you. Hey, Joe, Mary, how you doing? Come on in. Yeah, they come back and, oh, I want to surprise my spouse or what have you. Well, on this day, they allowed him in. The estranged husband went to the classroom and shot her in front of her class, and in doing that, struck one of the kids in the class. And this was, I think, a first grade class, if I remember correctly. And so no one knew that they were having issues at home. So that could have been prevented. So here what they've done is they've really restricted, because of this, who has access to the schools and stuff like that, because, you know, there were questions about how was he able to get in and things like that. But had she, you know, informed her job, and maybe they did know, and maybe they didn't take the extra step of, you know, letting the proper people know that he was not allowed in. It could have saved her life and protected the little one. And I believe the little boy ended up surviving, which was a good thing. But still, he was hospitalized for a while and had some issues. So, you know, those are things that protect not only your employee while they're at work, which is our due diligence as a company, but also protect others. So when I've had team members let me know that, I had one lady a couple years ago had this happen, and I told her as soon as she gets it, please provide us with a copy of the restraining order. We got pictures of this person. We got the information on the vehicle he drove. That way, you know, if he did come to the work site, we could spot him quickly and be able to make sure that we protected her and the work, you know, side of him. So those are things that, you know, to keep in mind and to helping protect these employees when they're kind of in your care at the workplace. Okay. Some other facts about this. This law provides that an employee working for an employer with at least one. So like I said, it covers employers of all sizes, but there's different coverages depending on the size of company. And this is rare. Not many laws break it down like this, but this one does. So if you have at least one employee, but less than 14, an employee shall be entitled to a total of 4 work weeks of leave during a 12-month period. Now, again, this does not have to be consecutive. This is something that they may take a day here or there. Let's say they may need a week or 2 weeks. They may need to move or get other places to live and kind of, you know, rework some things in their life. So this allows them time to do that and return to work rights, which means they're able to come back to work to their same or similar position. Employees working for an employer with at least 15, but not more than 49, shall be entitled to 8 weeks. And you may be thinking, well, why are they, you know, having different time off or different sizes of it? The law does recognize that when you're a small company, it's hard to allow for certain things, right? So like FMLA has 12 weeks off. If I have only 5 or 10 people in the workplace and I have 1 or 2 that are out on FMLA, that's going to really hurt my business. So that's why some of these leave of absences have an employee count tied to it, because the idea is that the larger I am, the more I can, let's say, maybe move around resources to be able to absorb missing this persons during that time versus a smaller employer. So employees working for an employer with 15 but less than 49 shall be entitled to a total of 8 weeks during a 12-month period. And then employees working for an employer 50 or more entitled to 12 work weeks during the 12-month period. Okay. So these are all the things that an employee, again, may take this leave. And again, that's the acronym VESA, right? To seek medical attention, psychological injury. So medical attention doesn't necessarily have to mean the MD doctor. It could be, you know, therapy and things like that. Again, not only for themselves, but for their household. So if they have a child or another victim in there. Obtain victim services, obtain counseling, participate in safety planning, whether it be temporary or permanent, and also seek legal assistance. So anything pretty much that connects them to that event or that reasons pretty much are covered. Anything for them to get assistance. Okay. So that's the end of the VESA leave. We have the Employee Sick Act. That's in Illinois. So one of the things that the federal government keeps teetering around are the requirements of having some type of mandatory paid sick time for employees. So because federally they still haven't decided to make that imposition on companies, a lot of states are enacting their own. They've done it for federal contractors and employers, so there's some ways that they've enacted it with some employers, but they haven't yet to do it across the board. So Illinois is one of the states that has created their own employee sick leave policy, and this is a paid leave. And this requires employers to allow employees to use at least a portion of their sick time, to have sick time and to care for themselves and relatives. So employers are required to give 1 hour paid sick leave for every 40 hours worked, up to a maximum of 40 hours per year. Now, you guys have some local ordinance, like in Chicago and some cities, some larger areas, that have different accrual and benefits amounts. So if you'll be operating in those areas, you definitely want to familiarize yourself with those. The Act requires employers to allow employees to use such times for absences due to an illness, injury, or medical appointment of the employee's child, spouse, domestic partner. As you see that in here, again, when we talked about FMLA and talked about spouse had only covered man and woman spouse. It didn't cover same sex. So this is a way that Illinois are covering and recognizing not only man-woman spouse, but potentially a domestic partnership as well, which has their guidelines with it, but could also be covered with same sex. It covers sibling, parents, mother-in-law, father-in-law, grandchild. So you have the list there to be able to have that employee to get sick time, paid sick time, and use it for their illness, and also for others covered under there. The Act defines personal sick leave benefits as time accrued and available to an employee to be used as an absence for work due to personal injury or illness and medical appointment. So it says personal. We're going to get into workers' comp a little bit later. That's a different type of leave that'll cover other type of injuries or illnesses. An employer may limit the use of sick time to care for a relative as described in the Act to an amount not less than the person's personal sick leave that would be accrued during the 6 months. So they have different ways of saying it. Some states say up to half of their accrued amount and things like that. So, and some companies say, you know what, you've accrued the sick time. We're not going to get so much in the weeds where we're going to be actively managing whether you have what portion is for yours, what portions for the other covered people. And sometimes it's just easier that way to just say, this is the time that the law says you need to have. Whatever you use it for and how you use it is how you use it. When it's gone, and it accrues back again in accordance to the law. Okay. The next law that Illinois has, and I'll have to tell you, I've done handbooks and different guidelines for many of our main states and things, and this is a rare one that I haven't come across. This is very interesting that Illinois has this law, but this is the Illinois Child Bereavement Leave. So this says that eligible employees of public and private employers with more than 50 employees are entitled to a maximum of 2 weeks or 10 work days of unpaid bereavement time following the death of a child, which is very interesting. And this is in lieu of, I guess, of employers having a personal leave policy that they've built this in. And its employees may be entitled to up to 6 weeks of bereavement time in the event the death is more than one child during a 12-month period. So really that grieving and allowing that person to be off to do what they need to do. Again, it is unpaid. So really it's more of a law around job protection and allowing them that time off. The time may be used to attend a funeral or alternative to a funeral, make arrangements, to grieve. The leave must be completed within 60 days after the date the employee, a date of the incident. Employers are entitled to 48 hours notice before the leave unless it's not practical. So a lot of laws have that where it's, they must provide notice unless practicals are always the caveat. So, you just pretty much say, you know what, we're just going to try our best to accommodate these different leaves. Do I see a question?
Yes, the question is about the sick leave that was, I think, on a previous slide. So for the sick leave, did you mention 1 hour for every 40 hours?
I'm sorry?
For the sick leave, was it 1 hour for every 40 hours?
Yes, that's correct, for every 40 hours work. So if someone's full-time and 40 hours a week, pretty much it's 1 hour for every week that they work. Where it can get a little bit tricky is if you have part-time employees and things like that. One of the best things to do is if you have a payroll company, and we'll talk through that in our session 6 about setting up and having certain services and foundations and things for that support HR practices, but it's having in your payroll provider set that up where it automatically calculates that. And then it only covers straight time. It doesn't cover overtime and holiday and stuff like that, those hours. It's actual working hours as well. So that's one of the easiest ways to keep track of that, because a lot of these keeping track, and as you get a good group of employees, not even let's say 50, if you once you start getting let's say 15, 20 employees, and you're trying to track the leaves and track this and run a business, it gets to be a lot. So that's one of the ways it can make it easier for a company to maintain that without having to really give much attention to it. Mhm. An employee also under this child bereavement leave is eligible for leave after they've worked 1,250 hours of service within a 12-month period. So as you can see, it's very similar to FMLA. And so what they did is, because FMLA didn't necessarily cover this portion of it, they have done their own state kind of addition to FMLA. Because as we recall, FMLA does cover to care for a sick child or dependent, but it does not cover if you're, things, this worst case scenario, if you're caring for a sick child and they pass away, if that employee, time off to bereave them and things. So I think that's great that they've added, this on. Okay. Our next one goes to the Illinois military family leave. And so again, this is one that's also an extension to FMLA. So we have the part of FMLA, and this is also kind of an extension to FMLA and parts of it to the USERA, the leave that we talked about earlier as well. So where it covers time off and different things for the employee due to illness, but what about other things? So this provides, the Illinois Family Military Leave Act provides family members of service members with up to 15 or 30 days of unpaid leave, depending on the company size, when that service member is called to military service lasting more than 30 days. This leave is modeled after USERA, but provides family of service with members of leave, right? So we have the part of FMLA that provided leave if the family member, the service man or woman, is injured or caring for that. But what about when they're deployed? If you're a spouse or a child of a family member that's going to be deployed and they're going to be going overseas for a year or two, and it may be months before you see them, we want to spend that time with that loved one before they go. And if you work for a company that maybe has 20 employees or doesn't offer vacation or any other time off, you don't want to have to risk your job so that you could spend time with that family member. So that's so this law allows for that time. Okay, so it goes on to, it also expands the definition of military service. The military service, as previously discussed, were primarily federal based. These are a little bit, it sounds like, more locally as well, adding some federal things to it. But for example, service covered under the Illinois State Guard Act. So where of course that wouldn't be covered in USERA because USERA is federal. So any local kind of things as well. So, and this also covers a period during which service members are absent from employment for medical or dental treatment related to a condition, illness, or injury sustained or aggravated during the period of active service. So there's also an expansion to the FMLA portion. So not only does this allow for, say, time off to be with that person, but if I'm myself that service man or woman or spouse or next of kin to them, and they have a condition that's aggravated from the time that they were active, then it's covered under this as well. So let's say they, suffer from PTSD as maybe as major as that, or this law, as I read, was as minimal as even dental services that may have come from it. So this is something to definitely watch out for and be aware of. Okay. All right. The next one goes into what's called the Small Necessities Leave Act. This act gives employees the right to take leave for family obligations, provided a limited number of hours annually. And for things that are not covered under FMLA, again, Illinois is trying to fill in the gaps of FMLA, of what could take an employee out of work. And again, the concern is keeping them employed by having those return to work job rights. So this covers parents to attend school-related events and activities, and it says how much time is allotted for that. This is to accompany children of the employee to routine medical or dental appointments, vaccinations. This accompanies an elderly relative of the employee to routine medical. And this is interesting because, again, some states don't have this, and a lot of our laws do not cover us caring for our parents. And where we have an aging workforce and a lot of what they call the sandwich generation, right? Where we are taking care of our children, we have our spouse if we're married, but then we also have our parents that are maybe living with us. Some of us even have had grandparents that we're caring for. So this also covers that portion of that, which is great, because this is just the reality that we live with. And we, again, don't want to have someone's job be removed when you think about it, right, based off of their familial obligation. So again, trying to find all types of ways to keep someone employed. And these don't necessarily mean paid time away. It's just job protect and allowing them to go do what you have to do for your family. Your job is here. Okay, and to be eligible for this leave, an employee must have been employed with the employer for at least 12 months, work 1,250 hours during that time, and 12 months with that employer, and then some of the same guidelines that FMLA does require in regards to size and distance and things like that for the employer, and then employee having worked there a certain amount of time. Another leave that many states have adopted is some type of school visitation leave. Again, we recognize that, you know, we have not only an aging workforce, but we have an active workforce with families and parents and things. And so a lot of states are supporting families. So in 1992, the Governor Edgar signed into place, it became active 1993, a law granting for leave for employees to attend school conferences, classroom activities for their children, and such activities that can't be scheduled during non-working hours. And for any of you guys who are parents, you know that your kid's schedule becomes your schedule, and trying to figure out work around that, where, you know, it comes to meeting with the teacher for parent-teacher conferences. Sometimes that's during the daytime. You even have some states that even allow for time off for school activities that cover school performances and things like that, that can be during the day, and different things that it cover for if you have to go see your child's principal during the day. There's even stuff for that. But these leaves are put into place. Again, not saying that it's paid unless they want to use their 6-hour vacation time for it, but allowing for that. The act applies solely to public and private employers with 50 or more individuals in Illinois. The employee must have been employed at least 6 months and have been employed at least half the time. The employee can be granted up to 8 hours during any school year and no more than 4 hours in any day. So this also looks at not being able to, they can spread it out. They may not need, excuse me, pardon me. Oh, excuse me, my mouth got dry for a second in my throat. But no more than 4 hours can take it in one time. So a lot of times employees may just need an hour or two here and there to leave early, come late, maybe in the middle of the day, take an extended lunch. So it doesn't actually require a lot of time out of work, which is good. And this time for these situations can only be taken if the employee has exhausted all accrued leave time except sick or disability leave. So if anything else that would apply has been exhausted, then they're able to use this one. Okay, Workers' Compensation Act. Workers' comp is a system of benefits provided by law to employees who experience work-related injuries or occupational diseases. Generally, benefits are paid regardless of fault. So most states have a no-fault workers' comp, so which means that whether the employer had an issue at work that was not, let's say, maybe a safe environment, or if it's the employee's fault. And I want to say 9 times out of 10, it's really the employee's fault. Unfortunately, that as an employer, it's just a part of doing business where we end up eating the cost for. And so that's why a lot of companies in their handbook policies will have no horseplay, things like that policies, because we're trying to limit those oopsie daisy situations in the workforce. I had a situation where I had an employee that was casually decided they were going to sit on a folding table at work, and the table collapsed and down they went. So that was a big hit to our financial, because you can imagine going, having the table break and falling down, that did not feel very good. So that employee was out. I had, when I was working for a bank, I had two employees that were, not paying attention, and one was coming down one hallway, another coming down another hallway, and they ran into each other. So they were out for a little bit of time. Thank goodness that one wasn't as extended, but to have a workers' comp claim filed because two people ran into each other. There's times when employees have, we're reaching for something, and a step stool is not always handy, so they decide to climb up on a chair with wheels or a desk, and the chair is moved out from under them. So you can imagine that one. So there's all types of ways employees can hurt themselves, and there's simple ones where I had an employee that just was walking and just happened to, for whatever reason, trip. There was nothing there. They tripped and hit their knee, but they were at work. So guess who it's on? So, so that's why it says no fault. It's just a part of doing business, and that's why we want to make sure that we have insurance for that. Most employees who are hired, injured, or whose employment is localized in the state of Illinois are covered by the Act, but there needs to be some type of protection for employees that get injured at work. The Workers' Compensation Act provides that accidents that arise out of and in the course of employment are eligible to receive workers' compensation benefits. This generally means that the Act covers injuries that result in whole or in part from the employee's work. I'll tell you, one of the hottest items right now with the coronavirus is COVID and people returning back to work. The debate on whether, if I come to work and I have and I get coronavirus, is that now considered a workers' comp injury? And in work environments where they are not doing all their due diligence and they have an outbreak and things like that, depending on the state, it can be considered workers' comp. So I always, is working with different companies on that, having them making sure that with employees at work that they're exercising all care. Now, if it's determined that an employee was at a 4th of July gathering and got it there, that's a little bit different. But we had something, and I just saw in a paper on the local news here where I live in California, in downtown LA, we have a lot of manufacturing, especially for the garment industry. And a lot of times with those, they're not always the best environment, and they often get a lot of safety fines and violations. Well, this company actually had an outbreak of 300 employees that came up with the coronavirus that was tracked back to the workplace, and they had 4 who passed away. So as you can imagine, this is a huge issue. They have been since shut down recently as employees have gone home because they did not exercise the proper social distancing and things like that. So you can imagine that this is going to be very costly for them. And in some situations, I'm hearing from brokers that workers' comp is refusing to cover employers that are negligent in doing things like that. So, it's very interesting times, and in regards to how this is being applied to this that's happening today. Do I see a question?
Yes. So the question is, what type of insurance does a company need?
Workers' compensation insurance. So as you're starting to set up your business and the foundations, and you get your liability insurances and all that stuff, workers' compensation, if you're going to have employees, is mandatory. So some states do what's called self-insured. Usually those are for your larger companies, but what you're going to do is you get a quote from a broker, probably the same broker that may help you put your health insurance and other benefits into place. And based off of your industry and how many employees you're going to have and the work situations and things like that, they will come up with a quote for you. And then over time, as you don't have injuries, your cost of insurance can go down. So when you don't have what's called like an XMOD or experience rating with the company, because you're a new business, they're not quite sure. So they're going to give you a rate based off of, how your industry typically does. But over time, as you have little to no claims, the rates can go down because of that. Good question.
And we have another question. With regards to workers' comp, how is causation being proven in COVID cases?
Great question. They're still looking at that. They can do what's called source tracing, is what a lot of the public health departments and things like that are doing. In the situation with the example that I gave, the red flag was raised by a local care provider that apparently a lot of the employees were going to. So they're the ones that kind of raised the red flag. And when their local public health department went to the company and they said, hey, we need to get some information regarding your employees, who's out, why they're out. The company also did the no-no of restricting that information, not giving all the information. But as they started, finding out, okay, employee, where have you been? Have you been to any group events? Have you been to this and that? And if they're saying, no, I just go to work and come home, and they start looking and say, just go to work and come home. And as we see these other cases pop up and things like that, then they're able to trace it back to the source. And that's how they're able to trace certain outbreaks of coronavirus. They do what's called source tracing, and it's reported to the local public health departments and things. So we're able to kind of keep track of that and question where people have been, so to see if there are any groups of outbreaks somewhere. Great question.
Okay, another question. How much does workers' compensation cost the company per month?
It depends on the company, and so it all depends. Yep, it depends on the company, the employees, how much the employees are making is a factor of it. So when you're first going into, when you're new into business, they're going to ask you about the business, and they'll have a business kind of code that they will use as a guideline. And it's also based off of how much money your employees make as well, and the work environment and all that. So for each company, it could be a little bit different. And it depends on the company, right? So kind of like shopping for car insurance. If you were to say, hey, how much is car insurance? Well, what I pay for car insurance is going to be different from what you pay, even if we drive the same exact car, right? So even if we live in the same state, it's going to be based off of, am I a new driver, my experienced driver? If I use, the auto club and you have, State Farm. So those are the same thing when it comes to workers' comp also. Great question. Okay, and employers are prohibited from harassing, discharging, refusing to hire, or in any way discriminating against an employee for exercising his or her workers' comp rights under the Workers' Compensation Act. So you really want to be careful. And sometimes, I've been there. You have employees that milk the system and that will, get injured at work or do things to injure them at work and injure themselves, or do something that they know they shouldn't have been doing and get injured. So, and unfortunately, we have to, follow the guidelines and things like that. So, it can be frustrating because these employees are kind of on your books per se. They're being paid, but their work on site still needs to be done. And this, as you can see, is not based off of any type of size. So it can be, kind of painful for an employer to have a group of employees out that they can't necessarily replace long-term while they're getting treatment and things. And also being out on workers' comp doesn't necessarily mean that they're 100% out. That could also be accommodations with that as well. So it could require other types of limitations, whether it be a shortened work schedule, a temporary work assignment, and things like that while they're working through. In fact, that's something that you want to do. I've had employees that make, pretty decent money that get, put out on work, and we'll find something else for them to do. Everything from just sitting and answering phones and taking messages to, we used to have warehousemen that would, I had a warehouseman I suspected was kind of milking the system. So 8 hours, I used to just have him come in and sweep. His restrictions didn't say he couldn't sweep, so we had to clean this warehouse for a long time. I had an employee at one company that kept coming up with restrictions. This girl had so many different type of random things. So we just said, we'll have you sit at a desk and help file and help our medical department and file and get them caught up. And kid you not, she claimed that when she was putting something in a 3-ring note binder that she sprained or injured her wrist, so she could no longer do the filing and do that as well. So, so when I say it can get frustrating and people can milk the system, it happens. But then you also have the ones that really, need it, and things happen, and you want to make sure that they get well and they're doing okay. And, you know, it doesn't mean, some people say, oh gosh, this person's on workers' comp, I can't fire them. It doesn't mean that you cannot fire them, but you want to be very careful if you do. So for example, if I have someone that got injured at work and they were, you know, and they have to go out on workers' comp, and it's something that takes them out of work. And while they're gone, we're having, let's say someone work their station, and we find, oh my goodness, this person's been, you know, stealing from us or embezzling money. It doesn't say, oh man, they're on workers' comp, they're untouchable. No, they can still be fired, and their workers' comp benefits will actually still continue even once someone no longer works for you. But, you know, again, it's got to be something pretty egregious. So, okay. Oh, did I have a question that popped up with that one?
Yes, the question is, are all employees covered with workers' comp?
Yes, all employees are covered, and I will stress employees are covered. So anyone that's a W-2, excuse me, is a covered employee under that. And so that's another kind of area to kind of be aware of when you're doing employee classifications, to make sure you're not, to avoid paying workers' comp or the things that come with that, putting people as 1099, because if it's found out later that someone was put as an independent contractor and they should have been an employee, the law looks at it as, okay, you were trying to avoid, you know, paying that. Or if the person is injured and they should have had it, it can come back to haunt an employer. So yeah, so making sure that people are properly classified in regards to being an employee, and then yes, and they would be covered under workers' comp, under the company's workers' comp policy. Great question. Thank you. Okay. So we have jury duty leave, and I'm looking at the time, and I want to respect everyone's time for the weekend. So I'll start kind of going through the next slides a little bit faster. When I put these together, you never quite know how long it's going to take, but I want to make sure I, you know, cover things properly. But so we have jury duty leave. So this pretty much says, and all states are a little bit different, but the main thing of it that from state to state is that all employees are allowed to take time off to work and respond to jury duty summons. That is our duty as citizens to serve on the jury. Employers in Illinois must excuse employees from work to serve on a jury to report. However, it does not have to be compensated. It's just time away from work, and they can't be any way disadvantaged or put in a bad position because they got called to serve in the jury. And the companies can't try to help employees get out of it and all that. I mean, other than maybe giving a letter. We used to give letters when I worked in nonprofit to employees to let the judge know that the time off is, I work for, you know, employee works for a nonprofit or a small company and we can't afford it. So we give them a letter to help that. And I'll tell you, it depends on the judge. A lot of times, unfortunately, judges do not care anymore. So, but it does depend. So sometimes those work, sometimes don't. But it does not have to be compensated. And Illinois law protects an employee's job when the employee serves on a jury, and employers cannot terminate or penalize an employee for serving on a jury. Okay, optional leave of absences, and these are leaves that you can put into place that are not mandated by the law. Some time off, any type of time off or something outside of regular work days as time off can be considered a type of leave. So holiday pay or leave is not anything that's, you know, required or mandated, but having that time off. So sometimes companies will shut down, let's say the last week or two of the year for the holidays. Sometimes it's paid, sometimes it's not. Having holidays, paid time off for holidays, again, maybe 1 to 2 days, but are a type of leave. Vacation leave is a type of leave and a benefit. Bereavement for the family, and giving time off and even paid time off for the child to be able to do funeral services and things like that. It doesn't necessarily mean it needs to be extended. Usually it's about 3 to 5 days. I've even seen policies where we've had it where if it's a local funeral, then it's 1 day. If they have to travel, then they get longer time. And then we would separate sometimes between the immediate family member, so the spouse, domestic partner, children, siblings, and parents maybe have 5 days, and anyone that's like an aunt or cousin may have less days or something like that. So it can kind of get a little bit fancy when establishing that. Allowing for a personal leave of absence policy where no other leaves may apply for something, or for an employee to be able to, life happens, and just be able to take that time, whatever it may be, to be away from work. And again, because it's not mandated, a company can say, well, before you're eligible for that leave, that you have to have been working here 6 months or a year. You can have up to 30 days depending on approval, and if we feel like it's worth 30 days, we may do 30. We may only approve 2 weeks. Again, just trying to work with them to keep them employed. And for the most part, your state doesn't really have a pregnancy leave per se. Some of it's covered under FMLA, but only if you're a certain size. So you may say, well, we'll just kind of do 6 weeks, which is what a lot of companies may do, of time off for a woman to give birth. And then allowing for having these extra leaves are also considered types of benefits. So to attract and retain, the right employees, having these and showing that, hey, we care about you outside of what the law mandates. These are things that we put into place because we believe that you, our employee, is worth this. Okay. Leave of absence processes. So one of the things, you want to have a type of process, and part of that is the contact person. Whether that's be their immediate manager or someone else in the company that the manager can refer employees to, because that's half the battle, is finding out who qualifies and getting the right information to them. When there's not one designated person to do this, and it doesn't need to be someone's full-time job, but just a designated person to really keep track of the leaves, make sure that there's consistent policy and the flow is followed each time, making sure employees are getting the right and accurate information, then leave of absences can work well, and it's easy for the employee and the employer and getting that person back to work. When it's all over the place, it becomes very frustrating for both. It's hard for a company because then they're wondering, well, when did this person go out? How long have they been out for? How much time do they have left? And for the employee to not know the same thing, what all their rights are under those potential leaves. Having the form, so be mindful of any leaves that have required forms, like workers' comp has a form 45 that has to be filed with an injury. And then a lot of forms and sample forms can be found online at government sites. Like, for example, FMLA forms can be found on the Department of Labor's website. So there's a lot of free forms that are out there to Google and use as a tracking, so you don't have to create your own. So that's very helpful. And also have a system for tracking. And again, having that person be able to be the constant contact for that leave makes that easier. So especially in a situation that you have, let's say, intermittent time where someone's in and out, like an FMLA, where they have a certain amount of time or hours. If it's intermittent, how do you know where they are with their leave status if someone's not tracking the 2 or 3 hours here and there every day or every other week that they're out? Communications. The law requires a lot of these to be posted. Many of these are going to already be included in the labor posters that you get in poster kits. And then also when doing your employee handbook, you want to have it there as well to formally kind of let people know also what leaves are applicable to them at their workplace. So just quickly, we'll go through some leave of absence scenarios and just kind of seeing when these may, when you want to be aware of certain situations. So the first scenario that we'll go through is number 1. You have an employee who says that she is going through a bad breakup with her ex-husband. She doesn't want to go into details, but she does let you know that she'll need some time to go to the courthouse in the morning to file paperwork. What leave of absence would apply to this employee? And even if you don't know the whole long thing, if you put the acronym or something like that, that's fine. If you guys want to type the answers in the chat, then we can see if what you've come up with. Anybody want to take a stab at it?
There are no answers in the chat yet. I think people probably are still thinking like,
Right, right.
Okay, so Karen says VESA.
Yes, absolutely, Karen. Great job. So this is the Victims Economic Security and Safety Act. So absolutely. So that's one of the parts of VESA that allows an employee to take time off for this, for these purposes. Scenario 2, you have an employee who comes to you with the doctor's note that informs you that they are under their care. The note also informs you that the employee will need to have a late start for the next 4 weeks and begin their shift after 10 a.m. What type of leave might this fall under? Or what things maybe want to consider? Mhm.
Nobody typed anything yet. Oh, okay. James just typed ADA.
Absolutely. So this is a type of accommodation the Americans with Disabilities Act. So this one was slightly tricky because it's not, let's say, extended leave or time off, but just a modification to their work schedule, which you're right, James, falls under the Americans with Disabilities Act. The next scenario, you are an employer with 50 or more employees, and one of them says that they will need time off for surgery. They have worked for the company 3 years without a break in service. What leave would you provide them information for? Okay.
I know the answer to this because I've been on
Oh,
this.
oh. You can go ahead
Yeah,
and say it.
you already put it on the screen, FMLA.
I'm sorry, I hit the button right as you said the answer. But I have faith that you did know the answer though.
Yeah.
Yeah, so this one would fall under the Family Medical Leave Act because remember that they can use it for their own personal illness as well. Scenario 4, it's August and the kids are getting ready to go back to school. Your employee informs you that they'll need to leave early to attend back to school activities. Is there a leave that would apply to them?
I'm assuming that someone probably doesn't remember the act. Oh, Karen said, so everybody's typing yes.
Okay.
But that's the answer that they typed was yes. There
Right,
is
that's
a
I
leave
have
that would
to.
apply to them.
Yeah, and you are correct.
And they're
Extra
not
bonus points
remembering
for
it. It's the one with necessities in the title. School Leave Act is what Karen just typed.
okay. Yeah, school visitation, yep. So, and both of those could potentially be applied, but the primary is the School Visitation Act. So great, good job, good job. And the last but not least, you have an employee in the Army Reserves, and he brings you his orders to report to training. He'll be gone for 2 weeks. Is there a leave that he would qualify for? This was one of the first acronyms we learned.
Yes, James just typed you, Sarah.
Excellent, James. Absolutely. So as we mentioned, so USERA covers not only kind of like deployments and things like that, but can just be used for trainings for, and the reserves is a covered military department that would fall under this. And sometimes we had employees that would never get deployed or never officially be active, but just, I want to say it was like every 6 months or so, or once a quarter, they get called in for 2 weeks of training or something like that. And then they come back. So yep, and we would have to, we hold their job for them, and there you go. And that could be for many years, because I mean, someone could be in the reserves for, for decades. So excellent. Great job. Any questions?
So while we're waiting for questions, I just want to reiterate, because some of you may have joined after I said this earlier. I am working with my program manager at DCEO to find out more details on when the licenses will be issued. So as soon as she gets me information, I will be sharing that with you. Because as many of you are aware, we have support activities planned specifically for licensees. And obviously we had intended to start those this month, but since those licenses are delayed, those plans are delayed. And so we need to know that information for planning purposes. So James says, is there a Dropbox link to make up any missed sessions? Yeah, well, yes and no. Yes, the first 2 sessions that we had were recorded, and they're in the Dropbox. All of the sessions from 3 forward are recorded, and they are available through Zoom rebroadcast. So as soon as the rebroadcast link gets emailed to me from Zoom, I will send an email out to everyone that says, you know, here's where you can go to get these sessions. So the first 2 are in Dropbox, but after that, you can watch the rebroadcast. And the reason why we did it that way is because with the rebroadcast, for people who want to get the certificate for having attended all of the sessions, we don't have to, we can verify you very easily, because the Zoom link, you'll have to put in your name and email address. And obviously we can't do that with the Dropbox. So Desiree and I are going to put out a little like quiz for the first 2, in case the ones just you missed are the first 2, and those will be, those answers to that will be able to verify that you actually attended the first 2. Then that way we'll know you attended all of them, because everything else after the first 2, we'll be able to just check the attendee list. So yes, I will be sending that out. Look for an email from me between now and Monday, probably today, but between now and Monday. Okay, so someone said, hi, I've made up the webinar. I initially missed the first one by watching it from Dropbox. Can you also send me the test to receive a certificate? Yes, so what I'll do is I will send out just a blanket email with everybody that said, to everybody that says, okay, if you want to do the certificate, you can go follow this link, and we'll do something where it's somewhat automated so that we won't have to handhold the whole situation, because that could be an administrative problem and we could miss somebody, and I don't want that to happen. You're welcome, Lindsay. And are there any other questions? I knew there were going to be questions. If I talk long enough, there's always a question. All right. What are the most common legal issues you've encountered dealing with this topic, leaves of absences and disability compliance?
Yeah, I think the biggest topic I always deal with is ADA, because it's so broad and there's so many different types of disabilities and new disabilities that we're learning about. And then there's, you know, trends of things. I think the biggest one though is the portion regarding mental illness in regards to when a company can accommodate and when they can't. And I've had you know, both when we've been able to accommodate someone without any issues, and, you know, as they treated for bipolar or depression, we're able to provide them, you know, times off and work with, you know, as they switch their medications and, you know, and how they deal with that. But then there's times where we've had to let people go because they ended up being a potential threat or danger to the workplace, you know, maybe because they decided to take their medications or they don't want to get diagnosed or something, and, or, you know, their medication's no longer effective. So I think that's been still kind of like the trickiest ones to deal with. Everything else you can pretty much work between or kind of be flexible, but it covers so many different types of things that it makes it tricky. And then when someone needs to be out for an extended period of time, when that time cuts off and how long to accommodate for, and really working with them. I mean, because hopefully the goal is, you know, to get them back to work. So that's the ADA is probably still the most complex of the leaves.
Okay, another question. What are some of the best ways to support employees that have disabilities?
Great question. I think one of the best ways to support them or to provide them with different resources, you know, as you guys open up and get things established, I think one of the good benefits to have is to look into having an employee assistance program. Employee assistance programs typically don't cost very much, and depends on the company and size of company. But I would look into having that. You know, anytime you can provide additional resources for them. Another thing is that a lot of the insurance companies now are adding their own types of employee assistance programs and resources. Blue Cross even had a whole kind of EAP carve out that strictly dealt with mental illness. So that was something under Affordable Care Act, under Obamacare, that mental illness benefits were added upon. And so some companies still have that, even though there's been other challenges to ACA. But that's been one of the big benefits of ACA are those services that are already part of your insurance that employees can take advantage of. So just providing them resources, because that's a lot of times, right, when we have issues or run into problems, half the battle is finding out, well, where do I go to even start to get a solution? And once we get pointed in the right direction, then that helps takes a lot of the anxiety and stress off, because, you know, we know, okay, how to, what the steps to start getting this resolved. So, and for employees, that's the, you know, that's the same thing. So being able to provide them with some resources is good. Mm-hmm.
Okay, I don't see any other questions yet. I still have a few other things that I could bring up, that I actually need to bring up. For those of you who missed it, we did have a networking session in the last week of June. It went really well, and so we're going to be scheduling a few more. So you'll look for an email that covers those. Those will be, I think the schedule that I set out was for the last Thursday of each month. So you'll see July, August, and September. So at least we'll have 3 getting scheduled in the very near future. Also, the directory, I need to send a link out for that. So you can put your company's information in our directory for you guys to be able to network with one another, even if you don't attend a networking session. So if you're like a transporter and you're looking for a craft grower, or if you're an infuser and you're looking for a craft grower, or vice versa, you'll be able to find each other that way. We have another question. I do have one more thing to bring up. I'll jump to the question. Do you ever see other employees discriminate against those who have disabilities? Do you recommend a company ever explain to other employees why a specific disabled employee has certain accommodations?
Yeah, excellent question. I don't want to say they discriminate per se, but a lot of times will find out when it comes to, sometimes with ADA, when they don't know, why does this person get to come, you know, in and out, or have a late start and we have to be here, or workers' comp too, especially if they suspect, like sometimes we do as a company, that they're kind of milking the system. And, but we never divulge medical information. It's protected by HIPAA. So all we can say is, like, you know, if they come forward with concerns, like that's not fair, so-and-so's never here on time, or what have you, and just say, you know, thank you for letting us know, but we are monitoring the situation. And, you know, sometimes there are things that we can't divulge to you guys, that we have to do certain types of accommodation. So we kind of give our general kind of disclaimer to let them know that there may be more to the story than they're aware of, but we don't, you know, provide any details in regards to that person's medical condition. If that person decides to disclose it, that's on them, but we could be in trouble as a company for disclosing it. Mm-hmm. Yeah, excellent question. Because, you know, yeah, it does happen. People at work, I don't want to say discriminate per se, but sometimes they get a little sour, and, you know, things get said and things like that, or they over complain.
Okay. All right, so there's no other questions typed right now. I was typing the answer for that. What was the last thing I was going to bring up? And now I can't remember what it is. Oh, when is the next networking event? It's going to be the last Thursday. It's not up yet. There's like a process to get it up. It's going to be the last Thursday in July, which would be the 30th. So you'll get an email about that. And I think I said, I think I told Sin at 6 o'clock. So we'll be getting those set up here shortly. And then, oh yes, I know what else it was. Our next HR session. So our next HR session, our last HR session, I'll turn on my camera. Our last HR session is scheduled for next Saturday. Is that right? That's right.
I think so. Next Saturday. We start an hour later, I believe.
Yeah.
But yes, I can't believe it's done already, and it's been a great experience to present for everyone. And the next session is going to cover kind of just HR systems, setting up your payroll systems, if you plan to have health insurance, what to look for, how to shop for a broker, and kind of just other miscellaneous topics maybe that didn't fit cleanly into some of the other topics. If there's any things that anyone has, any specific things that they want addressed or something that maybe you haven't heard yet, feel free to message Trisha and let her know, because I'll be making tweaks on it throughout the week. Or you can just ask the questions and we can always address it, or if you want to put it in the chats now or something like that, so I make sure I cover it. But yes, I'm looking forward to it. So yeah, it's our last one.
And I am putting our generic email in the chat right now. So you can send any questions that you have on topics that you might be curious about that fall under HR but haven't been covered already to cannabis@the-prep-school. And then we will make sure that those get over to Desiree and that those questions get answered. And then also, if you would like to have Desiree, maybe possibly review any policy procedure manual or anything like that, or schedule one-on-one time, that's the email you could contact for that as well. Obviously, we are giving deference to people who have licenses, but I know no one has a license yet. So, but in your preparation, if you want to have something reviewed, you most certainly can. And if you want to wait until you get your license, you most certainly can do that as well, because we definitely want to make sure that we have enough time and our budgeted dollars allocated towards those who actually have their licenses. So with that said, I don't think I have any other announcements. So I think, and I don't see any other questions. So if you happen to be typing a question, hurry up and say something now, because otherwise I think we will be done for the day and everybody can then go out and enjoy their sunshine in whatever way you're trying to. Oh, what is our email? I just put it in the chat. So it says cannabis@the-prep-school. That is the best email to send stuff to. Because it gets monitored by multiple people. You send me an email directly, I might not see it right away. Or I might see it, I might not answer it right away. You send an email to cannabis@the-prep-school, it goes to multiple people in my team. And so even if I'm unavailable to read it, I can make sure it gets acted upon. So.
Trisha, I think, was there something else that popped up in the
the question was, what is your email?
Oh, okay. Is there something in the Q&A? I saw some.
Yeah, that's what's in the Q&A.
Question both. Oh, okay.
Yep.
Okay.
So thank you all for coming. Have a great rest of your day, and look for some emails with lots of different things, like I said, between now and Monday.
All right. Thank you, everyone. See you next week.
Bye-bye. Wait, oh. I'm like, wait, all of a sudden there were two things, but they were.
Yeah, that's what I said.
Wait, what?
Oh, wait. Oh, no.
But they were just related to the email.
Oh, okay.
I'm like, where did those come from? All right. So, we could probably do, that, and I gotta think about how to make this work. I was gonna say, we could probably do the follow-up for those first two sessions through a survey, and I know that's what we said before.
Yeah, like
So
survey.
my CRM system has a survey feature, which
Okay.
then gives me the ability to see who responded to the survey. What I don't know if I can do is put out a generic link to the survey that they could just go and like opt in and click on, versus sending, because typically with our surveys, we send a survey out via email and then they just click on it and then respond. I could possibly do it that way. So what I need to do on Monday, let me think, can I do that on Monday? I can send an email. What I can do is send an email to I can do some checking now. And if I can't find what I'm looking for, I can send an email to their support team to find out if I can do a survey that would be similar to like how a SurveyMonkey survey would work.
Okay.
So, that you just go and click on the pop-up or whatever, and see like what kind of options they might give me. Because I know that we can have, because the survey result, if they answer it, will then be tied to their record in our CRM system. So then we can be able to see who has attended every single session, because that's in our CRM system already.
Okay.
And then it'll be easier for us to manage because everything will be in the same system.
Okay. Yeah, either way, let me know.
Okay.
And then if it's in the CRM system, if you need me to just, send you the questions with the answers for someone to upload, or if we're able to do a SurveyMonkey, then I have access to that to, put it in there, set it up, whichever. Yes, let me know.
Okay, I will do that.
That done, yes.
Okay.
Well, all right, sounds good. Well, we got the last one next week.
I know.
Oh my goodness. It's kind of neat though to see it kind of all come together from our discussions earlier in the year through now. So hopefully they can start getting licensed soon though, to start putting all this into effect.
Yeah, I don't think it's gonna be soon. Just FYI. I think it's probably going to be September at the earliest, and I think that even that is aggressive. Like that's a hope and a prayer.
Right.
So, and because the dispensary licenses were supposed to come out in May, and those haven't come out yet. And my understanding is that they're not even going to start issuing those until August. So, and with those,
COVID cases.
So COVID cases in Illinois in general are fairly high, just because of, we have a huge population center in Chicago. Around the state, probably not as much. So like if you were to take Chicago out of the mix, it's probably not as bad. But COVID definitely impacted everything. It impacted all of this. And especially this last round of licenses, because the dispensary round was earlier. The grant really covered the later rounds of licenses. The application period got extended because of COVID, because the original date was March 15th and it ended up being April 30th. So you okay, well, they lost 5 weeks of review. They haven't been meeting. Nobody's been to an office. No employee of the state is working in any state office. So, and then my understanding is that KPMG is supposed to have been overseeing this whole process, and they forbade their employees from traveling, which is why the dispensary licenses got delayed. So you're like, okay, well, if those got delayed and they had those since January, then then what's going to happen with these when they actually didn't get them on time? They got 6 weeks in the original timeline, and nobody's been in any office to actually review any of them at all, because they were in the heart of the COVID period.
Yeah.
So that's one of the reasons why I was like really pressing my program manager, like, so what is going to happen now?
Right.
Because, and I told, and I said, I got subcontractors that we had things planned. I need to be able to give people a heads up to say, instead of us starting in July and figuring we're going to work from July to September, that it's really going to be October to January or whatever the time period is. But you got people under contracts that, they were expecting to have their people available to do certain work. So like with you, when your only employee is you that's doing the major work. So you can make it work. But if you've got other employees, like my marijuana consultant does, I need to be able to say, hey, can you make sure that your people are going to be available whenever that is,
Right, and that's the hard part, because you don't know when that is. Yeah.
Exactly, we don't know when that is. So that's why I'm hoping, and the state is very bad about sharing information, but that's one of the reasons why I'm hoping that my grant manager will make some headway. So what she's done is forwarded my questions to their legal team in the agency that covers the grant, and then their legal team is in contact with his counterpart at the other department. And hopefully we'll get some answers.
Yeah, I feel like that's consistent between states, and the lack of information for different departments.
Yes.
Give anyone.
Sometimes the lack of information even within a department. Because I've been into that. So I can just imagine how much worse it is, across departments.
Right? It's so funny. I was my son and I, both of our passports expired, and all the offices have closed. So in May, I put in for my passport because I have this crazy notion that I could hopefully sneak out of the country for a quick little trip at the end of the month. So I'm like, well, they haven't said we can't travel, and this other country says we can still come in for now. So I'm pushing through. And I sent my son's, so I did mine May 5th, and I know some of the offices were closed. They still, of course, cash my check. And they're slowly processing because people are in and out working from home and things. I sent my son's in the middle of June. Do you know that I've gotten his stuff back already, and I have yet to get mine back?
Wow.
Okay. Wow. And I said, I saw the envelope. I said, oh, good, my passport. And it's his stuff. I said, are you kidding me? And then I didn't include some of the originals. The lady was saying, oh, you need originals of this, that, and the other. And I said, I don't know if I have it, and the courthouses are closed. They got me that stuff so quick. I got his little passport card, his passport, everything. None of my stuff is back. I'm like, you know what? So, it's just interesting, just, the inconsistency already just within that department. And they said it's going to be done on a first come, first served basis. I'm like, well, where's mine?
Right. Sitting in a pile somewhere.
Right.
Oh, wow. That is nuts. Girl, it's different. Like having traveled across the country, going through these different states and seeing like how people are handling things is different. And then, you get used to when you're at home, like, okay, well, I know where we are. I know what phase we're in. I know what to expect. Right. So here I am. The other night I had a call, and before the call, I was like, oh, I'm going to order some food. And so I went on, the hotel had given us a list of what's open and how you can go about getting food. Okay. So for every restaurant, it was like, here's what's open in the area. And then if they're doing delivery, pickup, eat on a patio, whatever.
Right, okay.
So I'm like, oh, I'm in Maryland. I want crab. Let me get some crab. Here's this plate.
Yeah.
So I ordered food. At least I thought I ordered food.
Oh,
So
no.
I ordered the food. I went on DoorDash, placed the order, was in my call. In the middle of the call, looked down and went, this order didn't go through. It was canceled because the place is closed. I was like, oh, so now I'm trying to figure out, well, what am I going to eat? What might still be open? Do I even want to go out in these streets?
Right. Oh, no.
Yeah, so I went to the grocery store and I had brought some like fruit and stuff with me in one of those freezer bags that I had put in my car. And so I was like, I'm just gonna cook something. So and then we went out last night and picked up some food, but it was like, it's way too many people out. I don't know about this.
Yeah, are they doing dine-in over there?
They're doing, certain places are doing dine-in. So I'm in Maryland, technically.
Okay, not to see.
So they're doing like dine-in at 50% capacity, but some places are doing outdoors. Some places, and I think restaurants are picking and choosing like which they want to do.
Right, okay.
So we went to a restaurant. I ordered on DoorDash, but I'm like, it'll be quicker for us to go pick it up, and it was literally like around the corner. So we walked over there to pick up the food. We basically stood outside and just waited till our food was there. Brought the food back. And then we went to, he was like, well, you want to go have a drink? He's like, I want to go smoke a cigar. Okay, fine. So we went to this bar, but we didn't stay in the bar.
Oh, I was gonna say the bar was open there. Okay.
The bar was actually open, and I was like, "Is people in here? I don't know about this."
You know, and that's what they shut our bars down because people were having too much fun at the bars, and that's how we got to get spread again. But yeah.
Yep. So there were probably, and it was close to closing time. There were probably, I'm gonna say, maybe 10 to 15, maybe about 10 to 15 people inside the bar. And it was a small place. And then, but we got our drinks. We walked outside and they had people outside, but outside was full. So we were like, I was like, we're gonna be able to walk on the street like this? He's like, just hide it. Okay, so we just walked.
And were people wearing masks also or no mask?
They had masks on. Everybody in the bar had on a mask.
Okay.
People outside, it was, most of them had on masks, but some people were like, okay, I'm just with the person I'm with, so I'm taking my mask off. So people were walking around a lot of people were walking around outside with masks on. I would say it was probably like 80% with masks and 20% without masks. And but a lot of them, most of them did have on masks. We eventually just went and found us a spot, like it's in an area that's kind of like a pier. I'm in National Harbor, so it's kind of touristy around here. So there were like picnic benches. So they were like, not picnic benches, but like just benches outside or whatever. So we just went and found us a bench to go sit on, and he smoked a cigar, and we sipped on our drinks, and we were fine. But it was like,
that was nice. Okay.
So it was like away from all of the people.
Yes. And you had your people, and that was, yes.
It was just the two of us, and there was nobody else around us. So, and it was like in because where it was at, it was like, you have, it's kind of like boardwalk.
Yeah, okay.
So it was like, street going one way on one side, street going the other way on the other side, and we're right in the middle.
Okay.
So.
Okay, that's good.
Yep, so it was cool. So I was like, yeah, this was way better. At least we're outside, but we're not amongst people. So today I'm going to see if I can get the room switched to a room with a balcony. Then we don't have to worry about people.
Yes. And then it's nice to have a little bit of being able to get out, socialize, and have a little bit of normalcy in these crazy times. So.
Yep. And I'm like, I can't believe I drove across the doggone country, but I wasn't getting on the plane.
Wow.
I was
Well,
like, I'm not getting on the plane.
well, I tested it. We went to about a month ago. My best friend got an Airbnb in Arizona. So my son and I, it's a 5-hour drive for us, 4.5 5 hours. And it was so cheap. We were able to do round trip for less than $200 for both of us. But the flight's only a 45-minute flight. So we risked it. We did it. We had our mask or whatever. And do you know it? Like the week after we got back, the Arizona had an increase in stuff because they were all their bars, restaurants back open. So, but we didn't go out much. We didn't go out at all. Actually, we stayed at the house and swam in the pool or whatever. And then last weekend we went to Vegas and we drove that because it's 3.5 hour drive for the most part from my house to Vegas. So we drove for the 4th of July holiday, and for the most part, the hotel required masks and stuff. Their pool was open, but they had they had lessened their capacity. They didn't have all the lounge chairs out and stuff, and they had where you had to wear a mask unless you were in the pool or drinking or eating something. Some people were better than others about keeping their mask on. But 4th of July, it was quite crowded out there. And so the hotel was trying to, do their best at reminding people. So, and we just kept our distance with the kids and stuff like that. So, but yeah, it was interesting, but Vegas still isn't 100% open. And, it's weird being there and not seeing the strip be the strip and
right.
out and about and stuff closing early. Cause usually most things are 24 hours and it's not. So,
Yep. And that's kind of what we ran into too. It's like, okay, well, we need to hurry up and order some food because like where are we going to get some food from? What's going to be open? Everything closing so early. And this is enormous. And there's a casino over here too. We haven't gone over there. And it's open. So
well, if you go, tell me if you go, please report back of how they're doing their thing. Because I work for a casino out here and we're open and all the safety guidelines and stuff that we've been putting in. So I'd be interested to see what they're doing over there.
We're not going. I can we're not going. We're not going. First, he has to have a surgery soon, and so he's like, they already told him like you're gonna have to quarantine before the surgery. Yeah. So he's all like, yeah, nah,
yeah.
So
yeah. Well, my friend's dad was scheduled for eye surgery, and there's a routine with a lot of surgeries are doing that. They're doing the Covet test before they do it, and that's how they found out he had coronavirus.
Wow.
Yeah. Because it's pretty much asymptomatic. He didn't have anything, and I was like, oh my goodness. So they had to postpone the surgery, and he was all mad. He was like, that doesn't affect my eye. I was like, poor thing. I'm like, oh, that's gonna be so frustrating. But
yeah, I'm hoping he would be upset. He would probably be the same way because he's having a shoulder surgery. So he's trying to get it scheduled as soon as possible.
Yeah.
So, but yeah, it's a crazy time, and where we are, because I'm in a timeshare, so like all of the amenities are closed except for the pool. The pool is open, but you can only go for like an hour. You have to schedule time. There's only so many people allowed in the pool at a time, and then they clean it like incessantly throughout the day. So I'm like, yeah, I'm not doing that. So I even brought my swimsuit too, like, well, maybe I might want to swim. Nope, not getting in the pool. So,
yeah. Wow. Yeah, that's what we were at our timeshare in Vegas, and they had the pool was open. It was interesting because they had the pool open, the gym was open, but then the business center wasn't open. And I was like, well, maybe because it was more inclusive, but I was like, well, everything else is. And they did limited food service that they only had open pretty much that weekend, room service, but we didn't even bother. It's connected to a mall, so we just found a place in there to eat, but and to actually order out from, because I still don't trust sitting inside any place or whatever.
Yeah,
so.
Not doing it. Only reason I think we went into the bar is because he wanted to go buy a cigar. So we had to go in for that and go in to get the drinks. But as soon as she made our drinks and as soon as we got a cigar, we were out.
Yes.
And a matter of fact, and we ran into somebody on the street that he knew. And the dude shook my hand. And you should have seen me trying to like put the straw in my drink without touching the straw. I was like, okay. And I'm like, he shook his hand. I don't even want to. And I'm like, pushing on the paper, trying to push the straw down in the drink and try to put the paper off, like, because I don't want to touch the straw. Because this man just shook my hand.
Right. You're like, either I find some sanitizer or.
They had sanitizer right by the door at the bar, and I didn't see it on the way in. On the way out, I put my drink down, sanitized my hand real quick.
Oh, goodness. Oh, man, the times we live in.
Girl, it's crazy. It's crazy. It's crazy.
It is. Well, enjoy your trip. Please eat some good crab and food for me. Oh, I know that's some good eat over there.
Yes, I'm supposed to meet a girlfriend for dinner tonight, so I'm going. And I was just looking at the menu, like when you were doing your session. I was like, ooh. So yes, I'm gonna eat good tonight, and hopefully tomorrow too, before I leave on Monday. So I will see you. I'll get back to you on the survey thing, and then I will see you next week.
All right, sounds good. Have a great week. Have a safe drive home.
All right, thank you.
All right. Bye-bye.